Hi, everyone, and back to our last session for today. It's about the regulation in property rentals, tedious bureaucracy, or the best way to protect tenants. As the UK government continues to push for more scrutiny in property rentals, some landlords feel that there's too much red tape involved. As a landlord has to comply with over 170 pieces of regulations to rent out their property. Should property rentals be deregulated, or is increased regulation working in the favor of protecting residents' rights? The first speaker I would like to welcome is Rebecca Francis, who is an associate director at the law firm Osborne Clarke. She acts for a variety of clients in the real estate and infrastructure sector. Welcome, Rebecca.
Good evening.
Hey. And then the second speaker is David Votta, who is the vice president of the ARLA, Propertymark, as well as the owner of Votta Sales and Lettings, an independent estate agency. We had some technical issues with David, so I assume he will be joining as soon as they're resolved. In the meantime, Rebecca, should we start with, what is your feeling about the regulation in the current market? Do you think it's like a positive thing or a negative thing for private landlords?
Well, I suppose this is where actually David's viewpoint will be very interesting, because obviously he's at the coalface with the clients, with the landlords, and obviously the tenants. Whereas I do a lot of advisory on what you need to do, but also then I see the other end of things, when you're trying to get possession or you're trying to sell when things have arguably gone wrong. So, from my perspective, are they sort of fit for purpose? And I'm talking, as you said, the whole host of regulations, Tenant Fee Act, EPCs, gas safety, electricity certificates, and so on and so on. And they've all been brought in sort of incrementally. I think if you take them as a package, as a whole, I don't think anyone would argue that standards haven't improved sort of across the board over the last, 6-7 years. So something has caused that, and it probably is a mixture of the various bits of regulations, but there's lots of other factors as well. I think if you're thinking about sort of private PRS, maybe buy-to-let landlords, obviously, if they don't use agents, or even if they do, it's much more challenging, I would argue, for individuals, accidental landlords, to try and keep abreast of all of this. And obviously there's a cost impact. Whereas I suppose with your institutional landlords, they're better equipped to perhaps absorb the changes, particularly if, they've got the technology and the platforms already inbuilt and ingrained to sort of automate as much as possible. So, it probably does have a sort of disproportionate impact on landlords. But I think when you get into the nitty-gritty of some of the regulations, I don't think there's anything that you wouldn't say could be better. And obviously something comes out and there's a period of adjustment, and then it goes through the courts and things change, like the gas safety sort of fiasco a few years ago, where essentially it said if you didn't do it at the outset, that was it. You could never get your tenant out from a no fault basis. But luckily, again, that's now been overturned. So it's a classic sort of lawyer's answer, in the fact that on one hand, there are obviously positives that have come out, and the intention behind it is obviously sound, but there's been a lot of tinkering and a lot of layering, and obviously right to rent is incredibly controversial, and remains so. And you do wonder the sort of maybe unconscious, but the discrimination that arguably has come out of some of that legislation, that.
Do you think that people often misunderstand the law? So, for example, in fintech, we had this digital KYC. So effectively people, making a selfie of themselves, uploading a picture of their passport, and it was sufficient to kind of verify the identity of a user. From my understanding, in real estate, the requirement was very specifically written that it needs to be checked in person, that the document's actually correct. On the other hand, in my opinion, it doesn't really make sense that I can open a bank account, but I can't rent a flat, right? So do you think there's a misunderstanding on the regulations, or could it be that, certain regulations in real estate are not perfectly written down?
I suspect it's more of the latter. I mean, if you look at any of the housing legislation, it's not modern, and it doesn't really fit with the newer products that are coming out. And everybody wants to digitize, or particularly institutional landlords, BTR landlords, want to digitize the whole rental letting process. And actually, again, if you get in the nitty gritty of some of the more archaic legislation, some of it doesn't fit quite right, but it just works. So in terms of that right to rent, I think you're right. Some of it is so prescriptive, and some of it just doesn't fit with how people want to let in the modern day. But things like COVID have forced a change. They had to relax those regulations on right to rent to allow virtual compliance. And you do just wonder that hopefully, well, I say hopefully, some people may not be for that, because there's obviously the risk of fraud, but you think there could be enough safeguarding in place to make it happen.
No, that makes sense. So with the increase in virtual viewings and online rentals of properties, do you think there has to be more regulations coming in to that whole framework?
Well, I think given the number of regulations there already are, you're sort of loath to say add more to the layer, maybe improve what's there. Obviously, you picked up on virtual viewings specifically, and I suppose the issues that can come out of that if it's not exactly as a tenant thinks it's going to be, the actual property. But rather than sort of additional regulations there, I think it's a consumer law point. I think you've already seen a lot more guidance coming out from the CMA, particularly over COVID and the application to tenancies. And I suspect the sort of unfair trading practices regulations will develop around this area, as obviously it's becoming much more common. But then equally, I suspect the tech and the virtual viewings will get better, and hopefully plug some of those gaps where the complaints and the issues are coming from, where, assuming people aren't maliciously misleading people. So hopefully that balance will slowly sort of redress itself. But I think it's more of a consumer point rather than a sort of strict landlord-tenant.
It's interesting, for example, if you... hi, David. Well, let's see if it works now. Well, in the meantime, so what I found interesting is, so basically, like, you can order like any product online, right? And you have the right to return it within 14 days because you ordered it online and it might be, not what you expected. The same law is not applicable to renting. So I could order like a flat online and I can't cancel it, right? Return it. But there seems to be one edge case, which is effectively if the property is not as advertised and there was misleading information, you have up to, I think, 30 to 90 days to actually cancel your tenancy agreement completely legally. So do you think, like, that there's a lot of that maybe the market needs to be better educated about actually the law and like how this can be used to provide a better experience to both tenants as well as landlords?
Well, 100%. And I would say, in theory, there is that right, but it actually is quite a high hurdle, I would argue, at the moment for a tenant to actually prove that and take steps to actually unwind the contract, essentially, particularly if you're getting pushback from the landlord. I think there are, particularly for managing agents, obviously, because they're caught by it as well as landlords. There is guidance out there, but I question whether there's enough. I'm not an agent, so I'd leave that to David. But certainly, I just think there is no getting away from the fact that this will become so much more of an issue. I imagine virtual viewings are here to stay, even if it's a hybrid. And I think there will just be more guidance and more training, and institutions like David's will have to get more up to speed, because I don't think just heavily caveating all of your virtual viewings, it will be sufficient.
That makes sense. So What new regulations or enforcement methods will have to emerge in the light of future trends in real estate, such as, for example, regulation to protect tenants from bad surprises in a property that weren't evidenced online? Do you think the current legislation is enough?
I think actually time will tell a bit on that, because I think already, as I've said, I think the consumer angle is going to be where it's at. And I think that's where you're going to see most of the testing coming out of that, and stress testing the current consumer laws and consumer regulations. So I think I'd say watch that space in terms of that area. And I suppose that fits quite neatly with real estate as a service and everything that's been spoken about at the summit already in terms of customer experience. It's much more of a consumer piece than a traditional landlord-tenant piece. And I just can see that just evolving further. And there just has to be a bit more harmony between the two regimes, I would say, because I think for lots of people get often quite surprised that consumer law even applies to tenancies. I think that would be my first point. I suppose building safety has to be fundamental. Obviously, you've got your you've got your electricity and gas safety inspections, but with the building safety bill going through everything, the sort of fallout from the awfulness of Grenfell, you're only going to see more protections and schemes to help make sure tenants feel safe and get the information that they need. So that's going to be, I just don't think landlords can really escape that. And also, I think in terms of, just in net zero and decarbonisation, again, the whole focus on that is just going to ramp up. So I think, again, there's already things coming down the track. There is only going to be more, or there's certainly going to be tweaking of what's already in place.
So what? So I can just give you share my experience. I mean, I haven't done anything with real estate like 2 years ago, and I had to learn a lot of the regulations, read them over the last year and a half. And what I found quite challenging is that there's often multiple conflicting views on the internet on how things should be done. And it's not very clear for someone.
The internet is a dangerous place.
Yeah, who's right? So what kind of guidance or advice would you give landlords or agents to get a better understanding of, the regulatory requirement and how that fits into their business?
Well, obviously take legal advice would be my my top tip, but I suppose it's just making sure you try and get information from legitimate sources. And obviously, if you're using an agent, there are industry bodies that compile guidance, that reply to government consultations. But ultimately, so much of the regulations when they first came out, there were holes and there were issues, when you try and apply them in practice. So they will evolve, and there still are issues. But luckily, what we have seen over the years, it's been quite slow, is that there have been some changes as a result of sort of pushback from the industry. And just, my example of the gas safety certificate, it wasn't drafted perfectly. There was ambiguity, but that has thankfully been resolved. So I don't know if that really answers your question, but you do need to be careful about where you're taking that guidance, and that's why, unfortunately, if you're a buy-to-let landlord, I think really you'd be very brave to go it alone without a professional managing agent these days, given how much you have to comply with and how easy it is to get wrong.
It's crazy because half of the UK private rental stock is still. It's kind of off the grid, managed by individual landlords.
Well, that's actually a really good point, because I think, and I was going to be interested in David's perspective on this, but we've got all this regulation, but enforcement, arguably, there's a big.
That was my next question. So if I look in fintech, right, you have a regulator that verifies that you actually implement the required regulations in your business, right, and make sure that you comply with all the rules, and also penalizes you in case you break some of these rules. There doesn't seem to be really a regulator in that sense in real estate yet. Do you see that as an issue to, on one hand, have consistent and streamlined regulations, but on the other hand also making sure that they're correctly implemented?
I think that very slowly we will get to that point, and I think that's probably because a lot of the enforcement falls to the local authorities, and so it's just not feasible to expect them to enforce. From my perspective, I actually see a lot of the teeth for these regulations fall where landlords realise unless they comply with it, they may have issues getting possession, or they may have issues when they come to sell their asset, because if a buyer's solicitor is doing their job, they should be asking about compliance with all of this. So unfortunately, that I feel is where a lot of the teeth are. I mean, obviously, if there's potential criminal sanctions, particularly if you're an institutional landlord, you're going to want to make sure you're compliant. But some people just don't realise that, especially accidental landlords, they're not going to be so familiar with the consequences. So, enforcement action may end up, getting taken against them. But I think one of my concerns with the government's proposals to scrap no-fault evictions, so the Section 21 procedure, which was the consultation started a few years ago, is does that remove some of the teeth? As I was saying, if you take that away, there has to be something to replace it and to sort of bolster the enforcement side of things. And as part of the consultation around that, they're talking about a dedicated property court and, so on and so on. So I just wonder if that's the time to make sure that there is a sort of specialist, task force to make sure that all these many regulations are actually being complied with.
Yeah, just for the audience, like if you have any questions for Rebecca, feel free to write them down in the Slido tab. We'll pick the top ones. For me, like going back on this point on the regulator and like that it's currently not really streamlined, to give like an actionable item, which I found quite struggling or where I struggled is, so effectively you are required to have certain amount of certificates and licenses if you want to operate in the private rental sector, whether this is, renting out the complete property or just operating as an HMO provider. And it's not very clear what licenses and certificates you need, because every council can kind of define their own rules. And so it's very hard for us as a software provider to map out, like what is the requirements and make it easier for landlords, because we don't really, know up to the point where the landlord tells us like, oh, this is what I need to do, right? So yeah, how do you cope with that? Did you run into this similar issue in the past?
If talking about HMOs, I mean, yes, 100%. It is. We've seen lots of landlords get caught out by the varying requirements of different local authorities. I mean, it is a problem, and unfortunately, the only resolution, much like all the planning issues, it is only going to get resolved centrally. So there's not a huge amount we can do. All we can do is just appeal a lot of the time to the local authority and just sort of say, if there's issues, it's not malicious. It is because, you can interpret your guidance one way or another way. And we do sometimes find that local authorities are quite amenable, and they are willing to engage and have a conversation rather than just, strict compliance and computer says no. But I mean, you're right to flag it. It is an issue. I don't know what the answer is. I'm afraid.
I mean, would you say like a risk-based approach could work, where you basically try to estimate the risk and then just make a business risk decision? I guess it's a bit difficult for private landlords because you can't spread your risk, right?
Yeah. And some of the, sorry, if we're moving off of licenses, if we're just talking about the sort of regulations generally, there's one thing to do that in terms of some of where it's just the risk of not being able to get VP or, potential fines. You may be able to deal with that, but criminal sanctions is something you probably can't spread that risk in the same way. So particularly if you're, buying an asset that's got tenants in situ, I think you're...
Oh, here we go.
Amazing.
David can have the final word.
Oh, no, sorry about that. Apparently it doesn't like iOS, it doesn't like iPads or iPhones or old iPads or anything. So sorry, guys. It's a learning curve for me. So I've had to use my wife's laptop. So sorry if it's a bit pixelated.
That's fine. Maybe we like a question we ask in the beginning is, so 71% of buy-to-let landlords feel unfairly targeted by the government's property regulations. Source is a survey of the English private landlords by FJP Investment. From your perspective, are the regulations fit for purpose?
No. In a nutshell, I mean, there's hundreds and hundreds of regulations out there and so much to adhere to, yet they're not being enforced. You know, so the thing is, the regulations would be fit for purpose if there was enforcement behind it. So it's like having a sandwich with no filling. It's just absolutely pointless. So in a nutshell, no is the honest answer to that.
Yeah, that makes sense. Like we discussed earlier that effectively, like in finance, right, fintechs have a very clear regulatory framework. And then effectively there's a regulator that enforces it and has annual reviews on the company to check kind of like, you know, if the rules are actually properly done. And any complaint goes also through the regulator. So from my experience, we really say nothing in that sense really exists, right? That somebody really says, look, the business is not fit for purpose. Here's an issue, you know, that's not properly done. Yeah. And do you feel like that's the last missing piece to kind of like enforce these regulations?
Yeah. Well, I mean, obviously they're bringing in ROPA, the regulation of property agents. Now that could be in the next 2 or 3 years, but then they've got to look at the framework for that. How is that going to look? You know, and the proposal is everybody that is director level, you know, that's doing reserved activity. So your lettings manager, possibly your negotiators would have to be level 4 accredited. But we don't know if that's going to be set in stone. Because if you imagine you've got, I don't know, a company director that's been in the game for 25, 30 years, right? And they're not level 4 accredited, then they've got to go back to learning. Now, level 4 is different to level 3. Level 3 is multiple choice. It's technical, don't get me wrong. Level 4, which again, I haven't done yet, it's on my radar of things to do, you know, as well as learning how to use technology. Level 4 is quite something altogether because it's essay based. So say, for example, it asks you a question, one question, and you think, oh, I know the answer, but then there's 10 points on that answer. So you've got to cover the legislation, the year it come in, the acts that it relates to, scenarios. So it's really quite robust. So it's interesting. I would like to think that when they bring in regulation of property agents, it will be very strict. However, when we look at, and I've got some people that I know at trading standards, I don't mean to speak ill of them, but there's not enough enforcement there. There's got to be that lead enforcement authority that actually gets something done. You know, if you've got, but what you get, and sorry if I'm ranting a bit, but as an estate and letting agent, I see both sides. So I'm the servant of two masters, so the tenant and the landlord. And what you'll get is the tenant will be in a property, they'll complain, work won't get done if they're with a self-managing landlord or an agent waiting to hear from the landlord, and they'll feel that the law favours the landlord because nothing's getting done. What do I do? How do I get this done? But then on the flip side, you've got a landlord wanting to get possession of their property. You know, they've served a Section 21. 6 months has gone by. They're in a queue of the other 65,000 cases that are backed up in court. They can't get possession for probably 18 months. And that tenant can sit in that property without paying any rent. So the landlord then feels that the law favours the tenant. So the trouble is, what we've got is a legal system that isn't fit for purpose, and it doesn't help anyone at all. And I can't see why they've put certain things in place, but there you go, ran over.
Yeah, I think, I mean, like, the interesting thing is, so I rented with one of the biggest agencies in the country, and now a month after my move-in, I haven't received an inventory report. So,
oh, you're joking.
Yeah, and the other thing is, which is probably a bit more severe in terms of their fault and potential risk, is I didn't receive like a deposit protection certificate that is signed by them and also by me. And, you know, like, it's quite surprising, you know, like an agency that manages over 10,000 properties to not...
How long you been in there?
Like a month. but I paid my
a month.
deposit like 49 days ago.
Yeah. So, the deposit regulations gives you 30 days in which to get the prescribed information served and signed and dealt with.
I know. Otherwise, I get
Great.
triple damage.
Well, yeah, up to 4 times the amount or the judge's discretion. So shocking. And that is the thing. Now, your experience of letting agents is going to be a poor one because you think you've used a big reputable firm, but they failed to do.
Most people don't actually know about this, right? I mean, like, I know about it because I read on it
textbook.
because I'm from my company.
Look,
but most people don't even know that it needs to be signed.
It's one of the most basic bits of regulation, deposit regulation. Rebecca, it's so easy, isn't it? Everybody knows.
It's been around the longest. I mean, but
only since what, 2007, 2006.
But it is. You just said it's amazing. Then, and that how easy it is to fall foul of it. And then, as you add layers to it, particularly when it's not particularly well publicised, and particularly when legislation comes out 2 years ago and then says it's going to come into force in however many months, and it applies to certain tenancies at different times, it is understandably very challenging. And that is, I was going to say that's why you need a managing agent, but it sounds not a panacea.
Well, a good one.
A good one, exactly.
David, like, what do you think is like if you're a landlord, right? Let's say I'm a new landlord, whether I'm a corporate landlord or a private landlord, or maybe even an existing one that been in the market for a long time. Where should these people go to get a good understanding of what is required from them to operate within the regulatory framework? Because as we mentioned, there's over 170 regulations, right? And it's quite confusing what needs to be done on a local council level.
An accredited agent. I mean, obviously, I'm biased because I'm the vice president of ARLA Propertymark, and I completely understand what you get. Now, there's a lot of people that are members, and they don't understand the full benefit. And they say to them, "What does my membership do for me?" And I say, "Well, do you go on the website? Do you attend the webinars, the seminars, the conferences? The various training courses available? Do you look at the fact sheets? Do you call the legal helpline?" I mean, for about £350 a year, you get quite good value. But it's like a lot of people. It's like saying, "Do you know what, Rebecca? I don't like that software you've provided me." You say, "Okay, well, run me through it." "Okay, I'm doing this, this, and this." "Okay, well, David, you're only using 5% of the functionality of that software. How can you judge how good it is when there's 95% you're not using?" So to answer your question, Valentin, you need to use an accredited agent that's experienced. You need to look at their Google reviews. You need to see how they're faced, and don't do the old thing of price, because if these surveys come out from Rightmove and other companies, and they say we've surveyed thousands of landlords across the country and found out what's important to them, and at the top was relationships or something like that. That's rubbish. The first question a landlord will ask is, "What's your fee?" "What's your fee, David? What are you going to charge me?" And I always say, "I'll charge you this," but the fee's irrelevant at the moment because you don't know what you're going to get for your money. Well, you're an agent, David. All agents are like banks and do the same job. Well, it's not really that true, because if a property's been on the market with one agent for a couple of months and nothing's happened, then the second agent gets it and lets it within 2 weeks. There's a real disparity into what that agent's doing and what that agent's doing, because one's hungry, one's a box ticker, someone that can just put properties on. So regulated, accredited agent that's got good reviews. A personal recommendations are also good.
No, it makes sense. So we're running out of time, but it's super interesting. So just to both of you, like, if you could change one legislation, what would it be?
Right to rent.
Tenant Fees Act.
Yeah.
So what specifically would you change about it? Maybe Rebecca, you go. Okay?
Rebecca, you go. I've talked too much. Sorry.
Well, obviously not wanting to get political, but I think my point earlier that I just do, it's arguably shifting what could be the government's responsibility and, one side of the argument. But my main concern is the potential discrimination angle. I think even not consciously, would people prefer a tenant that has got permanent residence or a time limited residence. And I just feel that is, putting an obligation onto people that really shouldn't be.
So there's still one question from the audience. Do any of you feel landlords take any notice of the rules of GDPR in practice? Same for most agents.
David's shaking his head.
Not really. I mean, only landlord that I speak to, we call it let them forget, because they just want us to set the tenancy up and then hand it over to them and we forget about it. I asked the question, are you registered with the Information Commissioner's office, right? And the answer is, what's that? Do I need to do that? Oh my God, really? It's like £40. Register. You're handling your tenant's data, so you need to be, well, I've got their tenancy agreement on a bit of paper, so it doesn't, well, no, that's not right. It's not right. So yeah, there unfortunately, yes, GDPR is a lot. I mean, I did a Propertymark GDPR session yesterday, and even I learned some additional stuff, and I'm thinking I need to put some additional bits in my staff contracts. So it's a minefield, but you've got to keep up with the regulations and the understanding, the knowledge, really.
But it will come. I think it is there's lots of lawyers that don't understand GDPR. Unless you are a data privacy lawyer, it's really difficult. So it's understandable if people don't. But it will. I think enforcement and fines, it will just become more prominent, particularly as it's much more data that people are going to be trying to capture, particularly if you're looking in the sort of institutional landlord BTR kind of world. So I do just think it's going to be heightened.
Yeah, I mean, from my experience, it's a very complex topic, because also there's some other regulations that override GDPR. So, for example, technically, anyone that has a business going on where they make more than 10,000, 15,000 a year from one client needs to go for AML checks, so anti-money laundering checks, and basically, because of anti-money laundering regulations, you actually need to store information about that customer, even though they request to delete it, right? And I think, for individuals, it's a very difficult minefield to navigate, where the potential damage is quite massive. So I agree, that it's probably better to kind of use a software provider or, an agent or somebody that handles that job for you. I mean, otherwise, registering for the ICO is not that difficult. But keeping track on all the data and deleting everything is a bit more challenging. And to be honest, I've seen over the last months, I've seen certain systems that I'm pretty sure are not compliant with GDPR. Cool. Well, it's great having both of you. Great to finally be able to speak with you, David, with a bit of beginning struggles. It's super nice. This is the last talk of today. It was really nice having both of you. I found it super interesting. What we're going to do is we have all the sessions recorded, and we're going to send an email in the next few days with basically information about each session, the recorded session, as well as additional slides and topics. So thank you, Rebecca and David, for joining us today.
Thank you.
And all the audience, I wish a very nice evening and speak soon.
Thanks very much.
Thanks, guys. Sorry about the technical difficulties.
No worries.
It doesn't like iPads. Yeah. See you later, guys. Bye.